Hello, fellow mediators, and welcome to this pre-mediation conference information session about the Mediation Act 2017. As you may have observed from your itinerary, Sabine Walsh and I will be speaking to you on Saturday about the impact that this bill is going to have on your practice, at least how we collectively and separately see that it's going to impact upon you, what we've spotted within the bill, and the opportunities that it provides. And I suppose I'd preface any talk about this to say you might as well see this particular act as an opportunity, as indeed it is, and it does clarify a good number of things. So it's broadly welcomed by me, and I can only speak for myself. I'll be putting some criticisms in there from my own point of view, but largely speaking, it's done what you'd hope a piece of legislation would do at a basic level, which is that we all now have a collective understanding or something we can point to say that's what we do. And we have some clarity around what should be contained in our agreements to mediate and other matters like that. But I get to them as we get into it. What Sabine and I do not intend to do on or at the conference is to give you a section by section run through of the act. But rather, what we want to do is pick out particular themes that are relevant to your practice as we see it, and maybe how you can adjust your practice to best fit with the law that we're now going to be governed by. So I suppose what I'm going to do then with this recording is to try and prepare you as best as possible for that. And people coming from different places here, so some of you are likely to know more than I do about this act at this point, and others of you may know less about the creation of a law than I do. Um, Either way, we've had an historic moment over the last few weeks where this bill has gone through the last few stages of its lifetime to become the act that was signed into law this week by Michael D. Higgins. And in as far as possible, I want us to have an informed discussion and a useful debate about, well, how should we be adjusting our practice and our practices to best reflect this new law that we have in there, and what work needs to be done still in relation to the regulation of mediation. So, in order for you to be best prepared for the conference, if you already know the contents of the Act, then this recording mightn't be particularly useful for you. I think either way, hopefully, I can provide something of use to people who've got a good sense of the Act, because I do raise a few questions about the wording of some things. But if you don't really know what's in it, then it's going to be particularly helpful, because I'll just be going through it section by section to say what this section is about. Then at the conference, we'll talk through the different themes that arise out of it and how we see it affecting our practice. There are 26 sections in the bill. They're divided into 6 parts. And really, what I want to do is show you these are the 26 sections. I want you to have a global understanding of it, and even just to listen to this, you might be in your car on the way to the conference, or something like that, just to get a sense of what's contained within the bill before we start to dissect the themes. Now, having done that, that should prompt some informed and tricky questions from you on the day. I suppose ideally you would send any, if you do have particular observations, or if you see some observation that I have made now that you think maybe I picked it up wrong, which is altogether possible or even likely, then I would appreciate if you would email me that question in advance. So there's my email address on the slide. That will also, if you email us questions, then the panel can look a little more informed and intelligent on the day as we answer it. If you would rather just ask me on the day, fire it at me, we'll see how I handle it. And yeah, Shinna will really. Then I suppose what do I want to see happen here? I want to see a conversation opened about the application of the bill now, and the actual how we should go about our business now that this law is here. And I suppose finally to say, why are we talking about this now? Well, we're talking about this theme because on Tuesday, the 26th of September, this happened, which is the Minister for Justice accepting an amendment that was sought by Shanna Daron about the Section 14 of what is now an Act. And so he's accepting that, and he's explaining his reasons why he didn't particularly like it, but he still wants the bill to become an act, so he's just going to accept it. We'll get to what exactly the point was when we look at section 14 itself. I suppose part of what I'm doing with this is, as well as showing you the 26 sections, I'm trying to give us a bit of a sense of the essence of lawmaking and the practicalities of it. And I suppose to lay bare somewhat to us all how a law is made. And in order to do so, part of what I'll be doing is showing you some clips of the discussions that were had by our lawmakers in reaching the decisions that they reached in deciding upon the law as it is now framed. You've heard about the mediation bill all year. Now I'm talking about an act. Why is that? Is because when the president signs a bill into law, it becomes an act. So what a bill is effectively is it is a draft act. I'll explain that a little further when we go into the act itself. But for now, this is our Minister for Justice in that seminal moment where the bill is being passed through the upper chamber of our lawmaking government for the final time.
The amendment to the mediation bill, which was passed in the Senate just before the recess, inserts a new provision in section 14, which requires a solicitor to advise a client that mediation is voluntary and may not be an appropriate means of resolving the dispute where the safety of the client and or their children is a matter of risk. I oppose this amendment for various legal reasons, and my views are on the record in both the Senate and here in Dáil Éireann following a detailed debate. I intend to keep the operation of the amendment under review to ensure that it does not have a detrimental effect on the effectiveness of the legislation, the fundamental purpose of which is to encourage the use of mediation by people to resolve their disputes, rather than going down the costly and often stressful route of court and court proceedings and all that entails. Of course, by its very nature, mediation is a voluntary process, and this is spelled out in the definition of mediation in section 2 of the bill. But in the interests of speedy enactment and implementation of this important and long-awaited bill, I am not opposing the amendment which was passed and agreed in the Senate. At least it was passed, wasn't agreed, but it was agreed by a majority. However, based on the amendment being made, I'd like to formally request a correction.
Just to speed things up a little bit here, this is the amendment that was put in to advise the client that mediation is voluntary, etc. And then the word "and" was put at the end of it. This was what the draft bill looked like before that. So you had A, B, C, D, and D being the obvious last paragraph in the section that was necessary. So he said, okay, what we need to do is we need to make the new amendment D and then make the next thing E. Okay, he talks about that for a while, so we'll go back to Minister Flanagan.
Can I repeat that court proceedings can be very costly, also can be very stressful, and of course are most time consuming. This mediation bill will promote mediation as a viable, effective and efficient alternative to such court proceedings. Enactment of the bill will speed up the resolution of disputes. Enactment of the bill will reduce legal costs associated with these disputes and reduce or avoid the stress involved in court proceedings, which by their very nature are adversarial. And finally, I want to repeat my thanks to deputies for their support for this important piece of legislation, and I would hope that we could complete debate on this issue in its entirety here this evening. But I'm in the hands of deputies in that regard. Thank you.
Thank you, Minister.
And so there we're nearly there. The amendment to be agreed, and you had Fianna Fáil and Sinn Féin stand up and say they were happy with the piece of legislation to move on as it was. You had Deputy Breed Smith stand up as well. She made a contribution, and then within it she put a slight spanner in the works for this final moment of moving the bill on to be agreed by the Senate, which has happened, and then to be sent on to Michael D for signing, but she remained confused by what exact change Minister Flanagan wanted to do, that one that I explained where he had to make it D and then put the word "and" after it and then make it E. the final paragraph as E. So she made him explain that again. So I'll just show you him explaining that, which is effectively the last thing that happened in relation to this piece of legislation, which is Minister Flanagan pretty much explaining that the letter E comes after the letter D in the alphabet. It's a little more technical than that, but that's kind of what he's doing.
I wish to thank deputies for their support and acknowledge their contributions. Can I say to Deputy Smith that the changing of the numerical order is merely to facilitate the amendment. The amendment, as passed by the Seanad, is being incorporated into this legislation. It's merely for ease of reading that the order of the paragraphs is changed.
And with the amendment properly read into the Dáil record, the Ceann Comhairle was able to say this.
Minister, so the Seanad amendment is agreed to. It's agreed to. Agreement to the Seanad amendment is reported to the House. A message will be sent to Seanad there and acquainting it accordingly.
And off went the bill to the Seanad then, just to show them that the amendment had been made.
A message has been received from Dáil and has agreed on the 26th day of September 2017 to the amendment made by Seanad Éireann to the Mediation Bill 2017. Leader.
And Michael T. Higgins got a hold of it on the 1st of October and immediately signed it into legislation, and that's where we are now. But there was one more message from Minister Flanagan's final speech, which I think I'd like you to prick your ears for this one, because he is effectively saying the job of creating our regulatory environment is not finished. The job of putting the meat on the bones of this particular act is not finished, and he's asking us as actors in the mediation industry to continue to engage with the lawmakers. So we'll have a listen to this final, what I feel is the most important part of the speech for the future, and then we'll move on to me addressing the 26 sections of the bill itself.
Once the bill is passed and enacted, I look forward to receiving submissions from interested parties regarding the publication of codes of practice for mediators under Section 9 and the setting up of a scheme to provide mediation information sessions for people involved in family law disputes as provided for under Section 23. In addition, I want to repeat my call to the various bodies active in the mediation sector to come together, to meet, to collaborate, to submit proposals regarding the setting up of a mediation council as provided for in Section 12 of the bill, because I believe the early establishment of such a body would provide a further stimulus to the use of mediation following enactment of the legislation.
And so we commence our analysis by, commencing how most such things happen these days. You're going to Google and search what you're searching for. So I'm searching for the mediation bill now, because it's only a day or two since the act was signed, and it's not available on the various governmental websites. So Google Mediation Bill 2017, and it's the first hit that comes up. That's the Oireachtas website. Once the bill is published, it'll be available on this website, and also it'll be available on this, which is a different website called Irish Statute Book. That's where all the laws in the country are collated, and you'll see here it's not quite available yet. Maybe they're doing up an explanatory memorandum or something and waiting to publish it on there. But the more useful one for the purposes of looking at the development of a piece of law is the Oireachtas website itself. So this particular page, and again, if anybody wants me to email on any links or anything like that, just drop me a line. So it shows you, and I suppose here is where I'll just talk for a second about the creation of a law, at least from my standpoint in relation to this particular law, is how it comes about. So a bill is initiated. That means some politician brings it into the chambers of the Dáil and says, I think this should be made a law, and it gets debated and tries to get over the line through various different stages. Sometimes there's stuff happens before the bill is presented to the to the Dáil. And that happened in relation to the Mediation Bill 2012. So there was a Law Reform Commission report, which is a very good report, very interesting read. Um, and that had sort of looked at how we should create a law governing alternative dispute resolution. And it proposed that we have a law that is mediation and conciliation. That got narrowed down to just mediation. We'll look at that when we get to the relevant section within the Act. But also there was pre-legislative scrutiny, and pre-legislative scrutiny is where different actors from within the mediation industry are asked to present in front of the Dáil their various concerns in relation to regulating this area. That happened for the 2012 bills, so various people from the various bodies within the mediation industry did present to government, including the former president of the MII. And part of the difficulty I have with that, though, was that that happened over 5 years ago, 6 or 7 years ago now. And best practice in mediation, that there have been new things learned since then, and there wasn't an opportunity with even within those few years for the Mediation Bill 2017 to before it started getting discussed by the politicians, have that basic input and basic current input. So rightly or wrongly, I suppose what did happen is it got the ball rolling by putting Mediation Bill 2017 in there. But by the way, in the creation of law, that's how it happens. There wasn't this pre-legislative scrutiny for this particular act, and so be it. So before the bill becomes an act, or what are we doing now? Like the good thing about this piece of regulation is we're now regulating. We point to a law that says this is how things should happen. Up to that, we're trying to create it ourselves. We had agreements to mediate, bound us in contract law to our clients, and one mediator's agreement to mediate might have had very different provisions from the next mediator's. At least what this law is doing is saying things like you need to have these standard things in your agreement to mediate, and other such useful interventions which are creating standardization. And that can be helpful for the public who are going to purchase mediation services, that there's some standardization out there and they have some sense that they are working within a market where the same thing is being sold by two different people to a degree. So anyway, the Mediation Bill 2017 as initiated gets put to the floor of the Dáil, and the Dáil can do a few different things with the law. What they decided to do with this law was to send it to a select committee, and that select committee had various politicians on it, like Jim O'Callaghan, Mick Wallace, Claire Daly. So they would have received it, gone through it, taken submissions from people, and then presented amendments to that. So I'll be showing you some of the debate that happened in that committee, particularly between Claire Daly and the Minister, in arriving at how the Act now looks. So anyway, as you scroll down through this page, you'll see it. You'll see the bill as it developed and as it changed, and they upload the different iterations of it, right down to it goes through the Shannon, and again the Shannon look at it and they say I want to make this change and such, and that's the legislative process that goes through the various houses, leaving it ultimately to what we have at this moment, which is the mediation bill is passed by both houses of the Oireachtas. Now that's the same as the Act, which has since been signed by the President. The only difference being this is bill across the top of it, but the content is the same. So I'm going to work off of this for today, because the Act itself hasn't been published as of yet. As you can see from Irish Statute Book, it's not yet available there, so it'll be uploaded here and it'll be uploaded in Irish Statute Book in due course. For now we're going to work off of this, accepting that the content is the same as what is within the Act. And so going into that, we'll see first of all that it's made up of 6 different sections. The first one is just preliminary, talking about the scope of it, what it applies to, what it's called, things like that. Then part 2 speaks about mediation in general, looking at agreements to mediate, the role of the mediator, confidentiality, etc. Part 3 then looks at the duties on actors within the legal industry to inform people about mediation, with part 4 then talking about that relationship between court and mediation, the extent to which judges can and should invite or encourage people to use mediation, and what carrots and sticks can be used to encourage mediation. Then part 5 creates a potential for mediation information sessions, schemes to be created into the future, and part 6 looks at amending other acts so that things purportedly anyway should gel smoothly as between the different acts. Then there's a schedule in relation to the setting up of a mediation council. That's the act in a global sense, and what I'm going to do now is go through the 26 sections to give us a sense globally as to what is within it. So commencing with this short title and commencement, there's other wording above that which explains what's within the act, but for now we're just going to go into section 1. Section 1 really just names the act and says when it's going to come into operation. Section 2 then is an interpretation section, which goes through what specific things mean within the act. I don't know if you've read Lewis Carroll's Through the Looking Glass, but there's a famous quote from Humpty Dumpty which says, "Words are what I choose them to mean." And here, this section says what within this act we choose particular words to mean. Some of them are a bit unusual, like dispute includes a complaint. So then it also means dispute. That's one that kind of confuses me. You can see within the debate between Claire Daly and the minister that there's a reason why they put this in, but why they didn't explain exactly what a dispute was. Anyway, make what you want of it. Really, what I'm telling you is that this section tells us what these words mean. So if you meet any of these words during the body of the bill, you can refer back to here and see that's what it means. Within here, I suppose some important one, and probably the most important thing with this section is that finally, at least now, we have a publicly accepted definition of what we do. What mediation now is in our code of laws is a confidential, facilitative and voluntary process in which parties to a dispute, with the assistance of a mediator, attempt to reach a mutually acceptable agreement to resolve the dispute. So we can all point to that and say that's mediation. You can disagree with it, but it's now set down in primary legislation. Reaching a definition in the first place is no mean feat. I mean, if you go back to the Law Reform Commission's report, they had to footnote a number of different definitions and accepted that there is no worldwide commonly accepted definition of what mediation is, and you'll see that different mediation bodies provide different definitions of what the process is. Either way, we now have a definition of that, and I certainly find that useful. Then various other things are defined. One of the definitions that gets a bit of airtime in the clip I'm about to show you is proceedings. That came out of a bit of confusion that particularly Claire Daly TD had around the scope of the bill. And I'm just going to go back to one of the previous iterations of the bill. So when the bill first arrived in the Dáil, this was what section 3 looked like. It started with, so it said this is what the bill applies to, and it said this act shall apply to any civil proceedings except for these exclusions, but any civil proceedings. Okay, that's an old version of it. The act that we now have doesn't say that. It just deleted it. So what the act applies to, you can see here between with this old version, Claire Daly, you started going civil proceedings. What does that mean? Do I need to have issued civil proceedings before I can go to mediation, or what does that mean? So she got confused by that, as many people were confused by that, and so what they did was, well, we don't want that to be the scenario, so we're going to define proceedings as something that may be instituted in front of a court. So that means, if I have some kind of a problem and it's something that could end up in court, then that's what proceedings are. But then somewhat confusingly, they just took out this reference to proceedings in what the whole bill applies to. And I'm going to show you now an exchange between Claire Daly and the Minister for Justice around this very question. And ultimately, where it arrives at now, at least my interpretation of it is, this isn't just an act that applies to civil and commercial proceedings. This is an act that applies to all disputes, really, which you will remember from the definition includes a complaint. So that seems to really broaden the application to more mediations, and I'm interested in other people's interpretation of this, and perhaps there are a number of ways of looking at it, and hopefully that's the sort of thing that we can tease out at the conference. Anyway, this is Claire Daly with those questions.
Clarify that the bill applies to a wider group of disputes rather than just those in which civil proceedings have been issued. I think we would feel that the use of the word proceedings is likely to cause confusion for the public and for the mediators themselves, and could give rise to a belief that in order for the protections of the bill to apply, proceedings will have had to have been issued, and it's to try and clarify some of those points. I know the Minister has an amendment in number 3 to change the definition of proceedings to civil proceedings that may be initiated before a court. So I suppose what I'm asking him to clarify here is that this amendment means that the bill applies to any dispute in which there is a potential to litigate, that the proceedings don't have had to have been issued. And I suppose if you could clarify that in the context of this amendment, what kind of disputes does the Minister think would be excluded as well from the provision? In any case, and even notwithstanding the Minister's amendment, I suppose the argument remains that for the avoidance of doubt in the public's mind, a dispute is better than proceedings. I think it heads off any potential confusion. I mean, this is a critically important bill as far as we're concerned. We want to encourage people to use mediation as an alternative to court. We don't want people thinking it has to go to the court process. There are situations where this could cause irrevocable, I suppose, damage, really. We say a dispute between neighbours or something. If somebody starts litigation, it's going very hard to come back from that and to go into a mediation process. So I suppose we want everybody to know they can get to mediation before it goes to court and have an early intervention to de-escalate things. So in that sense, I think dispute is better. I know Deputy Wallace has dispute rather than my wording, which is civil dispute, but I'm open to that. I'm wondering what kind of, does the Minister have any idea what kind of disputes are we envisaging that the amendment is going to exclude, or are there any
Well, I think it says anything that's capable of a civil action at some stage would be envisaged or could be the subject matter of mediation. The proceedings don't have to be prepared and served and issued.
Look, we can probably go with number 3 for now. I think that's,
Very good. Okay.
So I suppose make of it what you will. Either way, this is now what we're working with. This Act shall apply to any civil proceedings is simply gone. And when we look at what does the Act apply to, it seems to apply to all mediation. So, like for me, I'm a succession mediator. It could be just a family wanting to talk through somebody new coming into the business. There's no particular intention of it ending up in court. Under the old version of the bill, I didn't really think that this bill then applied to me, or this Act would apply to me, because it said that it only applied to civil proceedings, and that wasn't civil proceedings. That was just family talking as amongst themselves. Whereas now I think it does, because I don't see it being excluded in any way. I'm happy with that, by the way. I just, would it be helpful if there was something in there that said it applies to all mediations or disputes or something like that? Perhaps not. Anyway, the application does seem to be defined by exclusion rather than inclusion. So here are all of the exclusions. And as amongst the exclusions, again, I have difficulty with all these exclusions, to be honest with you. Why are all these things being excluded? It doesn't say easy, and I've heard various rationale. For instance, you might remember in the papers, the Revenue Commissioners had raised concerns about the mediation bill. So it seems whenever somebody raises concerns, what the legislator does is say, "Oh, fine, we'll just leave you out of the whole thing." So I don't get that. Like, if the Revenue Commissioners want to settle a case, and every case I've ever come across anyway can be settled somehow, particularly civil and commercial cases. So if the revenue want to settle a case with somebody, they want to talk to them, wouldn't they want to do that in a regulated and safe environment, such as the environment that's being created by this bill? But they now cannot do that because the type of negotiations that they want to get into are excluded here. So it seems like they're shooting themselves in the foot. Maybe somebody didn't think it through. Maybe I'm missing something here. I know in a previous consultation from the MII on the mediation bill, Cormac Dúlacan gave a plausible explanation that there might have been confusion between the advisory requirements in sections 14 and 15 of this now Act and the application of the Act at all in the first place, saying what the Revenue Commissioners didn't want to see happening was that they would have to get advice on these 10,000 different cases that they were going to be referring to the courts, and that would be a glut in the system and a waste of time and resources, and therefore we're just going to exclude ourselves from it so we don't need to be advised. That would seem like an inappropriate reason to exclude oneself from the application of an opportunity to mediate within a regulated environment for the likes of the revenue commissioners. That's just one of the examples here. There are, of course, other examples, and I could provide similar arguments as to, why are they being excluded from the whole thing. Surely there's a better mechanism for protecting those who feel mediation mightn't be the right solution always. Anyway, that's a debate that can continue, and it's not like the bill can't be amended if it's realised that it's appropriate to include these types of disputes in the future. Anyway, that's section 3. Now we're going to section 4. Section 4 and 5, both of them are administrative sections, really, with section 4 just allowing, creating a legislative basis for a minister to provide regulations subservient to this piece of legislation, very normal provisions to have in a piece of legislation. And then section 5 deals with similarly uncontroversial administrative matters relating to the expenses the minister incurred in the administration of this legislation. But getting back into the meat of how we're regulated, you see section 6 then is entitled mediation. Importantly, out of this, it provides that mediation shall be voluntary at all times, and that's participation in mediation. And interestingly, it doesn't say the journey into mediation. The whole bill does seem to accept that there's a difference between being prodded or forced or encouraged into mediation versus voluntary participation. That voluntariness has can be split into voluntary participation within the process versus some form of coercion or encouragement into the process. And some people say that bringing the horse to water is okay, or compromising one's voluntary entry into the process is okay, whereas compromising voluntary participation within the process is not okay. From my reading of this, that's in line with it. So again, this is just outlining it. Particularly, this part deals with voluntary, and then down here, subsection 9 says it is for the parties to determine the outcome of mediation, which is rubber stamping the principle of self-determination. And this second part of the Act Mediation in general starts to confer rights and impose obligations on you as a mediator. So perhaps this is a point where you should have the bill itself open in front of you as you listen, to just try and get a sense of what's going on here. For an example of a right that's given to you, here the mediator may withdraw from mediation at any time. So as we would already have that and probably built into your agreement to mediate that you would have signed by your parties or clients, now that's putting that on a legislative footing. But there's also then obligations such as returning fees and costs that are paid for work that isn't done. Yes, I'm sure you do that anyway, but what this is doing is it's giving somebody a piece of legislation they can wave in your face to say, give us back X, Y, Z. I suppose what I'm saying here is it's good to know exactly what is written in there before you have these things thrown at you. That brings on to section 7, and section 7 deals with the contractual nexus created between the parties and the mediator at the outset of mediation. It provides that an agreement to mediate must be signed by both the mediator and the parties prior to the commencement of mediation. So when is the commencement of mediation? It's saying you're going to have something signed. And it uses the word shall, which is very important. It doesn't use the word may, it uses the word shall. So you have to do this. It's an obligation. Um, so it's going to be, it ought to be strictly adhered to by mediators as the people who are responsible for this process. But I think anyway, such strict adherence could pose a practical difficulty for mediation, in that when conducting separate meetings at the outset of a particular case, some mediators refer to these meetings as pre-mediation meetings, whilst others use them as part of the mediation itself. So it's not really clear from the section whether the obligation to obtain a signed agreement to mediate arises in these meetings or before a plenary session when there's more than one party present. Just something I observe myself from my own practice and looking at this. I guess to be on the safe side, you need, when you meet somebody separately, you need them to get to sign these things, which can be problematic in some types of mediation, but in adhering to the letter of the law, best to err on the side of getting both parties to sign separate agreements first, and then maybe the same agreement on at the agreement to mediate or at the plenary stage. Also, Section 7 outlines the terms that must be contained in such an agreement. The Law Society provided useful input to the bill here, where they had this particular section added in. It allows the parties to include such other terms, if any, as may be agreed between the parties and the mediator. That reinforces the flexibility of the process, and I thought it was a good inclusion. It'll be interesting, though, to see how the quality of a given mediator's agreement to mediate is going to be policed. You know, what's going to happen if, for instance, the agreement to mediate omits to inform parties of their right to seek legal advice as required there under Section 7E. I guess it's only when it becomes a problem afterwards and somebody is saying they went in and signed up to this legal agreement without legal advice that the mediator then can become embroiled in the ensuing controversy. What I think you can do as a mediator to make sure that doesn't happen for you is to make sure that all these things are included in your agreement to mediate, and that the agreements to mediate are signed in advance of entering into the process. And again, looking at this from the positive point of view, I mean, it's great that we're not plucking our agreements to mediate out of thin air anymore. We now can look at this piece of legislation which is telling us you're going to need this in your agreement to mediate anyway, so these core items need to be within it. So what the Act does for us is it puts a structure on our agreements to mediate, and therefore in terms of process it provides clarity, and I suppose copper fastens a collective understanding of the process that we deliver, and therefore the contractual agreements that we need to enter into with our clients in advance of that. Okay, and then you have moving on to Section 8, which is the role of the mediator. The Minister, when he was explaining all this to the Seanad, he pointed out that Section 8, what it does is it specifies the actions the mediator must take prior to the commencement of mediation. And again, here you see you have the word shall, so you have to do all of these things. They're obligations placed upon you now by law. It provides the mediator must supply the parties with information concerning his or her qualifications, their training and experience, a copy of a code of practice to which he or she adheres. And so while all of that seems like a good idea, you now need to adjust your practice to make sure that all of this information gets to your clients and potential clients before you commence the mediation. So it's a good idea to begin to adjust your practice now to make sure that you have, either via a website link or leaflets, this information to hand to give to people. That's 8.1b, but 8.1a before that brings up something that I find doesn't sit easily with me, which is, again, we're under shall here, so this is an obligation. You have to make an inquiry to see if there's a conflict of interest. Okay, that's a good thing. And then if you believe that a conflict of interest arises, you shall not act as a mediator, and that's it. And you know, that says shall, but that seems to conflict a little bit from my reading of it anyway with Section 8.2a. The mediator shall also then, during the course of the mediation, declare to the parties any actual or potential conflict of interest which he or she becomes aware or ought reasonably be aware as such conflict arises, and having so declared shall, unless the parties agree to him or her continuing to act as mediator, cease to act as the mediator. So if you figure out that there might be a conflict of interest before the mediation takes place, you shall not act as mediator. That's what 8.1a says. Um, and Ireland's a small country, it would make more sense to me if they added the bit that's in 8.2a, which is, if the parties are happy enough for you to plough on, having declared what the potential conflict of interest might be, then off with them, and off with you. So there seems to be a bit of a conflict between those two things, where if you figure out a potential conflict of interest before the mediation, you just don't do it. Whereas if you figure out during it, then you say, well, are we okay to continue? And they might say yes. I think the are we okay to continue should exist for establishing this before the mediation as well. And so I'm somewhat uncomfortable with the way that's drafted. Moving us on to A2B provides that mediator shall act with impartiality and integrity and treat the parties fairly. Now again, we have shall here, so this is something you have to do. It's an obligation. And it does indeed seem an honourable and achievable expectation of a mediator on the surface. However, if you peel away the surface, the interpretation of the word impartial may not lend itself to an easy satisfaction of this expectation. What does it mean to be impartial? What if one party requires more time with the other? If you adhere to the principle of empowerment, you will give the weaker party a bit more time and bolster them up and get them ready to mediate. Is that you being entirely impartial? That debate that has gone on in so many of our sharing and learning groups. And are you compromising impartiality a bit there? And it becomes a bit more real now when you have this legislative obligation that you're going to be impartial. I know you just deal with it by explaining from the outset that I'm just empowering people and that I'm still remaining neutral. But I suppose it brings into sharper focus this debate around what is impartiality, what is neutrality. There are some commentators out there who advocate the concept of multi-partiality in mediation, arguing that impartiality in the strict sense is an inappropriate reflection of the work that a mediator actually does. It is not actually humanly possible to be all that. Impartial is another approach to it. So although this section may never be litigated on this particular point, the obligation to act impartially necessarily puts the principles of impartiality and empowerment into conflict with one another. That's something of a academic point, but academic points are all well and good until they may well come home to roost at some stage when you are accused of acting impartially. If one party sees you out smoking a cigarette with the other party because it's the only place you can have a cigarette in the hotel that you're mediating in, and they accuse you of being on their side more, suddenly this piece of legislation can create a difficulty. Anyway, subsection 3 then provides that the outcome of mediation shall be determined by the mutual agreement of the parties, and the mediator shall not make proposals to the parties to resolve the dispute. So this is designed to reinforce the principle of self-determination in mediation, i.e. that any agreement is of the parties' own making rather than that of the mediator. However, subsection 3 is qualified then by subsection 4, which provides the mediator may, exceptionally at the request of the parties, make proposals to resolve the dispute, but it shall be for the parties to determine whether to accept such proposals. Now, you might remember that the Law Reform Commission's report originally was a mediation and conciliation bill, and then they dropped all of conciliation to make it more straightforward that mediation is now the primary alternative dispute resolution mechanism outside of arbitration and litigation. Within the mediation and conciliation bill, they were able to distinguish between the two processes, and mediation didn't have this aspect which is being provided for here in section 8.4, whereby a mediator can, what I call the Superman Clark Kent provision, we can turn into a conciliator if he or she wants to. So what this is doing is, although conciliation has gone out of the bill, it's still allowing a mediator to turn into a conciliator if the parties agree to it. So there are issues there around distancing oneself and impartiality and neutrality, um, which, like it or not, it's now a part of the law that we have. But at least the word may is in there in relation to whether the mediator would do this or not. So if you want to be a purely facilitative mediator, you can just say, nah, I'd rather not do that. And ultimately, party self-determination is protected in word anyway, where because they say it shall be for the parties to determine whether to accept the proposals, and ultimately it's going to be the parties who decide what the ultimate agreement is, however much of the mediator's fingerprints might actually end up on it because of this subsection. And we'll move on in a moment now to section 9, but before we do so, I suppose the question comes up here about codes of practice, and it's also relevant to here within section 8 to section 8.1c, which is that a mediator shall furnish to the parties a copy of any code of practice to which he or she subscribes insofar as mediation is concerned. There's a concern with the use of any code of practice that you can just make that up, and it addresses it raises a broader question of protecting mediators, and who, if you are a member of the Mediators Institute of Ireland, then you are subscribing to a code of practice, or a worthwhile and recognised one. This doesn't say that you need to subscribe to a worthwhile and recognised one, and I suppose that's part of the difficulty that arose during the legislative process, that it doesn't appear to have, or at least the questions raised don't appear to have been answered, or perhaps it wasn't necessary for them to be answered. Section 9 says that the Minister may prepare or publish a code of practice. They use the word may, and you see the word may comes up a lot during the Act, particularly in areas where money might need to be spent, perhaps not obliging the Minister to have to do those things in the short term, but making provision for it to be possible to be done, and sooner rather than later, on the basis of the speech we heard from the Minister earlier on. So, but either way, all it's doing is it's saying may. So I'm going to play a piece from the Select Committee now, which is Claire Daly asking questions about the interplay between the fact that you can use any code of practice under Section 8, and then that Section 9 just says that the Minister may produce a code of practice.
Basically, at present, Section 8 holds that a mediator at the commencement of mediation shall furnish to the parties a copy of any code of practice to which he or she subscribes. So they could basically write something on the back of a napkin, as long as they say, this is my code of practice. And what my First Amendment tries to do is place an obligation on the mediators to subscribe to a code of practice, changing the any to the. And the Second Amendment is obviously linked to that it provides that all mediators' codes of practice shall incorporate in full the code of practice prepared and published by the Section 9. And actually, during second stage, it was even government backbenchers made the point that there's no point in the Minister publishing a code of practice for the conduct of mediators, only for mediators not to be obliged to follow them. It doesn't make any sense. And in that sense, Section 9 is actually undermined by Section 8, in that mediators don't have to sign up to it. And then all of the good aspirations, I suppose, in Section 9 too, about ethical standards being observed, continuing professional development, can be junked basically by a mediator and who's empowered to design their own thing if they want. And I do think, given that we were discussing in the House last week the regulation of other professional bodies, we need regulation here, and the mediators themselves want it now.
Indeed, Deputy Daly was quite exercised by all of this, and went on to say,
without this, I think we're heading into very dangerous territory. It leaves people seriously exposed to end up potentially in the hands of rogue operators to be exploited, which is something that we absolutely don't want.
So that's Claire Daly on sections 8 and 9. Jim O'Callaghan TD describes this issue of codes of practice, one versus many, perhaps in more illustrative terms. So I'm just going to show you what he had to say about that as well. And he goes on to raise the point about training and education standards, which the Minister then seeks to answer, and he tries to answer all three, both the issue with Section 8, the issue with Section 9. and the issue of training standards and how it's been designed into perhaps another part of the bill, and that it's something that the Mediation Council should deal with.
I suppose one of the main issues here is whether or not there should be a code of practice or a variety of codes of practice. My preference would be for the former. I think if we start going down the road of mediators having a series of codes of practice, we'd end up like boxing associations with different organisations having different codes of practice, and people being able to say, well, yeah, I'm regulated by the, the Malahide Mediators Business or the Rathmines Mediators Association. So I think the preference should be to have one. The Minister says there's an advantage in having more than one because, for instance, he may want to develop a code of practice for mediations that involve children. I don't see why we can't just have one code of practice, and that within that you'd have a section that would deal with mediations that involve children. Section 9 refers to there being a code of practice. As TDs, there's a code of conduct. We don't have a different code of conduct for different parties or anything like that, and I think we should be seeking to harmonise it in terms of one code of practice for mediators. And then just in the other amendments which are about education and training, as I said with report stage, we were going to put in something into section 9 in respect of the requirement that mediators should have to have a minimum standard of education and or training, and I think that should be put in it. Otherwise it's just open season, because it's not like any other professions where you have to achieve certain qualifications in order to become qualified to practice. Here, as Claire said, anyone can just call themselves mediator and off they go. So I think we need to be able to protect them. And just in terms of code of practice, like in court you have the rules of court. Like if you want to make mediation succeed, which we all want to do, you should have just one code of practice for mediators. There it is. Everyone knows what's in it and there's no ambiguity.
Thank you, Deputy O'Callaghan.
So just to give you a sense of what he means there by the fact that other professions are regulated in different ways, for instance, for solicitors, there's a prohibition on people pretending they're a solicitor, pretending to act as a solicitor in any way. And if you do so, you're guilty of an offence. So you don't have that in this Mediators Act. But anyway, further to all of the issues there raised by both Deputies Daly and O'Callaghan, this was the Minister's response.
Regarding the education and training, which has been mentioned, or indeed the qualifications, I would draw the attention of members again to the role of the mediator under 8.1, with specific reference to 8.1b, where the mediator would be required prior to the commencement of the mediation to furnish to the parties details of the mediator which are relevant to mediation. The matter of qualifications, the matter of experience, the matter of training, the matter of CPD and training, and also to furnish with a copy of any code of practice. So that does deal with the matter of qualifications, that does deal with the matter of training, that does deal with the issue of experience and indeed expertise. So I feel that that caters for the points being raised by the Deputy in a number of the amendments. And can I say, just in relation to education and training, and I accept the point raised by Deputy Wallace, but I would say to him that perhaps in this part of the bill, or in this bill, it's probably premature and therefore inappropriate to deal with that at this stage. The minimum requirements in relation to the Mediation Council, about which there's some reference in the bill, would deal with that. This will be an issue for the Council, and I refer to the schedule of the bill, which will impose a duty, an obligation on the Council to maintain and develop standards in the provision of mediation, including a system of training, education, professional development, acquisition or acquiring of expertise. I'm not against the point you're making. I just don't think it's appropriate in this part of the bill, and I don't think it's appropriate for this bill. Rather, it's a matter for the Council, and as you know, the Council will be a consequence in terms of the evolving nature of mediation and the law. And I would ask you to accept our bona fides in this regard. Thank you.
anyway, that's how he justified where things were at that time. So I suppose one thing that did get changed on foot of those representations was the word may there has been changed to the word shall. So we are going to get a code of practice. And really all there is to say further in relation, for me anyway, further in relation to codes of practice is that the Minister does have at the moment the code of practice that was agreed cross-party within the um, mediation industry in, was it 2014. So he has that to hand, and hopefully that will form the basis of a coherent code of practice coming to the fore, and hopefully sooner rather than later. So we're all signing up to the same thing, and again you get more standardization across the industry, and consumers of mediation services have more clarity around what they're getting. That moves us on to section 10. Section 10 then is the section on confidentiality. So I suppose the first thing to point out is that the process is confidential, and it has exceptions. That's not surprising, and we're used to that from our code of ethics and from our agreements to mediate. So these situations where one might need to deviate from the veil of confidentiality that is around mediation. So if it's necessary to enforce a settlement, if it's necessary to prevent physical or psychological injury, what does that mean? Where does it start and finish? Is required by law? Is that simply when a judge says I have to do it? Is that law? And then that it is necessary in the interests of preventing or revealing commission of a crime, etc. The one probably most relevant to us is that you can waive confidentiality, or you can breach confidentiality where the communication is sought or offered to prove or disprove a civil claim concerning the negligence or misconduct of the mediator. So there's a protection for mediators in there. And to that end, one wonders whether one should be retaining one's notes as a defence to oneself. But again, that's a whole other kettle of fish to open up that question about destroying or retaining notes. I suppose also to say the question of privilege and mediator privilege, what is confidentiality? Where does it start and finish? Whenever I speak about confidentiality, I would refer to Tony Allen's book, Mediation, Law and Civil Practice. Now, it's an English book, but he has a great point that he makes, that it is very worrying for mediators not to know the precise boundaries of the confidentiality which lies at the heart of the success of the process they deliver. And there are so many angles to confidentiality that I don't know if it's ever possible to fully understand all of its contours. So I think that's a sort of a self-fulfilling prophecy of worry that Mr. Allen prophesizes on there. And one of the questions that arises is the question of a separate mediator privilege. And privilege is like a subset or a type of confidentiality, meaning that a mediator cannot be compelled to give evidence. So there's Dáil privilege. You've probably heard about that. Mediator privilege, the question was out there as to whether there was such a thing. The potential that there is such a thing has been weakened, I feel, because it's not mentioned in this act. And if you were to raise an argument that I have mediator privilege, then surely the counter argument to that is, well, a law was written about mediation. You'd like to think that they consider all aspects of it when writing the law, and they decided not to include it. Therefore, where does that leave your privilege? So I think the existence or otherwise of a distinct mediator privilege, or this right not to be compelled to give evidence, has been weakened by the lack of its explicit expression within the Act. Then another point to make, I suppose, which was something of a success for the MII. I know that they or that we as a body lobbied in favour of this oral statements also being included, because originally as this bill was written, it could have pertained just to written statements, which could have caused a bother. So thankfully that's in there. Then finally, on confidentiality is the question of, again, this appears to me anyway to be silent on the question of non-party participants. It doesn't seem to be in there, and you'll see again Deputy Clare Daly raising that question and not receiving the clearest of answers on it, at least not to my mind.
But what I'm not clear on is whether is the non-parties. I accept fully that you're saying your amendment covers the oral issue, which is part of what I was trying to do, and that I fully accept that.
Oh yeah, all parties, yeah. The
But
mediator and the parties, yeah.
But what about the non-part, like the people who are, the Act provides them different, for somebody to go along as a support role. It can be a legal person, it could be a trade union rep, a community rep. Are they bound by they're not actually a party to the mediation, they're there in a support or observer role. Does that amendment cover them on the issue of confidence? Because they're not really a party, they're a non-party, they're just there as an observer.
Yeah. My submission, Chair, would be to members that 10.1 on the matter of confidentiality covers all records and notes relating to the mediation. And there should be no disclosure in any proceedings, either before the court or otherwise. I don't believe we can improve on that. I think it speaks for itself. It covers everything.
So make what you will of that, but I suppose in the continued, what I would see is ambiguity there. Perhaps it's a good idea to include in your agreement to mediate how to deal with non-party participants. What I do in my own practice is I would have a separate agreement to mediate, or add a clause relating to non-party participants. I would have the non-party participant initial or sign next to that particular clause to be sure that they're aware that the confidentiality extends to them. That's confidentiality. Section 11 deals with enforceability. One point to raise here is in subsection 2. Subsection 2 says that a mediation settlement shall have effect as a contract between the parties, except where it's expressly stated to have no legal force. So that could, I suppose, a mediator could end up sleepwalking their way into a contract there, because you could just draw something up. You don't necessarily say that it's legally binding on it, but here it says you need to expressly state this is no legal force. So you need to state that at the beginning of a memorandum of understanding or something like that to be sure that it doesn't end up becoming a contract. It's just one thing to be aware of in one's practice, and it's something we'll be covering at the conference. Then also under this heading of enforceability, you have 3b, which says that a court may, on application of one or more of the parties to a mediation settlement, enforce its terms except where the court is satisfied that a party to the mediation settlement has been overborne or unduly influenced by any other party in reaching the mediation settlement. So it would seem quite obvious to me that in order to prove this, there will necessarily need to be some evidence from what went on within the mediation produced. Therefore, I presume that this is the exception that then falls under. So is required by law. It does seem to me to be a case that a judge can turn around and say, well, I want to see whether there was undue influence, so no, I need the mediator to talk to me here, and I need the parties to disclose the written and oral communications. So that's a section 11. Again, with section 12, we'll speak more about the council, the existence of the council or otherwise, at the conference, and Sabine Walsh has undertaken to field any questions on that. What I would point out now again is you have the word may here, so there's no shall, so it doesn't. This doesn't have to happen, and then perhaps may not happen anytime soon. Section 13 then likewise deals with the council and just talks about the reports from that council. That moves us on to part 3, which is the obligations that are placed on actors within the legal industry or legal services to inform their clients of mediation. So this section 14 is the section which imposes obligations on solicitors to encourage mediation or to advise their clients to consider it. It asks them to do a lot of things for mediation. It asks them to advise their clients to consider it, and note here it's the word "and" is there, so they have to do all of these things. They have to provide them with information about mediators, and they have to provide the client with information about the advantages of it, as well as the benefits of mediation itself. So the advantage of it over litigation or arbitration. That's a lot of plugging expected by a solicitor of one dispute resolution mechanism over another, and mediation isn't right for every dispute, and that has been borne out in a number of judicial pronouncements in cases like Atlantic Shellfish and Grant. A few of the Irish cases that have come up that have dealt with the question of the reasonableness or otherwise to refuse mediation. We'll be talking about that in a while. So, if mediation is not right for every situation, then there should be some kind of counterbalance here, and that arose in relation to one particular type of case. It's a case where the health and safety of one of the parties or their children is at risk, and that's the amendment that the Seanad sought to have put into this act, which was put in, and it stalled the signing into law of the act over the summer. Um, this was what Minister Flanagan had to say about the reasons why he didn't think it was necessary. Now, he expands upon the reasons elsewhere. I don't really have the time to include all of them. But this is his statement in ultimately accepting this.
I felt in the Seanad that the amendment was unnecessary. I still feel that way, but I want to acknowledge the will and wishes of the Seanadori when the matter was voted upon.
So here it is now, is that solicitors also have to advise that mediation is voluntary, which does reinforce the voluntary nature of mediation, and that it may not be appropriate, particularly in those types of cases where the safety of the client or their children is at risk. One wonders, is this the appropriate way of making mediation a part of the dispute resolution culture? You know, forcing solicitors into a corner to say mediation is great. It's like we already it exists in the family law sphere and may or may not work to different extents. There's other ways of making people aware of the benefits of mediation. Not all solicitors are trained in mediation. It hasn't become a subject in the Law Society practice courses until very recently. So there are a great many solicitors out there who, quite understandably, do not have a strong appreciation of the process, and perhaps investment would be better placed in educating solicitors, giving them an opportunity to experience mediation, and an understanding of its benefits. Then there's also a question around, are they the right people to be giving the message, or could the message be given by somebody else? Could it be given by the court services somehow, or is there an even more straightforward way whereby there's a mediator phone service or a mediator online Skype or some similar technology type service where for €50 or so you can get a session with a mediator who can explain the benefits of mediation, rather than putting that onus directly on the solicitor. I suppose I'd like to see those things explored more, and certainly anything coming out of Europe, any of the studies that have been done on the various different European approaches to encouraging mediation in a given country, tend to point towards that this isn't quite as successful as information meetings that are disseminated by mediators themselves or by people with an appreciation of the process. And we'll speak about that again when we get to section 23. But these reports coming from people who've done comparative studies of different approaches within Europe do tend to point away from either the compulsions that are in section 16 and 21, or indeed these efforts to force solicitors into selling mediation, and point more towards these information sessions that are carried out by people with appreciation of mediation being the way to go. That's the most important point I suppose I want to make in relation to section 14. Section 15 then just covers the same thing, but in relation to barristers, looking at a situation where in the future barristers are likely to have direct access to their clients, and they'll have similar obligations to what solicitors have under section 14, bringing us to section 16, which has to do with the relationship between the court and mediation. And this is section 16 relates to the court bringing the horse to water, so to speak, in that it provides that a court may, either if asked by the parties, either one of them, or of its own volition, decide to either invite the parties to consider mediation as a means of attempting to resolve the dispute, and or provide them with information about it. Now, this section needs to be read in conjunction with section 21 particularly, and I would say also section 17, because section 21 says that if the court invites parties to go to mediation and the parties say no, then if they were unreasonable in saying no, the court can impose cost consequences on them. Again, the best practice message coming from Europe from their comparative studies is again that this may not be the way to go. This interplay between sections 16 and 21, and talk about that a little bit more when we get to section 21. Just sufficing for now under this that this invitation to mediate, you know, it used to exist, or it already exists under a variety of scattered court rules and pieces of legislation. At least what this is doing now is consolidating all of those into this one thing. Effectively, it says what a judge can do, which is invite people to consider mediation, or to and provide them with information about the benefits of it, and there are various associated supporting clauses going with that. Section 17 was for a long time the most controversial section within this particular act. It may remain so for some reasons. Effectively, the most important thing here, again from the MII's point of view, both the MII and the Law Society made submissions to say they really were uncomfortable with the reporting duties in the event that a mediation took place, but there was no resolution that a mediator had to report whether somebody was acting unreasonably or not. You could see the rationale behind that was that people would be, you know, forced to behave within mediation, but that really corrupted the essence of mediation. If it had gone through, it would have radically corrupted the essence of mediation. The minister did make the point that it exists in the Multi-Unit Developments Act. However, arguments tend to come back to that to say really the MUDS Act is flawed, and we're better off not replicating that in this piece of legislation. So thankfully, from my point of view anyway, thankfully we haven't. I would have felt very compromised as a mediator. I think what I would have ended up doing was telling people that, like at the very outset, if you don't want to do this, let's stop it now, and I will report back to say the reason was that it simply failed and nobody was uncooperative. I'm not sure how I dealt with it, and glad that I don't have to, and I won't be doing any multi-unit development mediations myself either. Anyway, within this section 17, there is still one issue, which is where the mediation did not take place. As a mediator, you still have to report, and you have to give a statement of the reasons why it didn't take place. So that could leave you exposed to saying something that a judge would pick up as being unreasonable on the part of one of the mediating parties. I don't think that's a good message for our profession to get out there, that we're a part of a design against somebody who's doesn't want to enter mediation for whatever reason. So my sense of it at the moment anyway is that we really should be neutral in our reports in order not to compromise that sense of neutrality and impartiality that we ought to have from the outset and right through the process. And that's, I suppose, it's the main point I want to make on Section 17. Thankfully, there is no reporting going on within the mediations, which would have compromised for all of the principles from voluntariness, confidentiality, self-determination, impartiality, the whole lot of them. So bring us on then to sections 18 and 19. So section 18 is a section that seeks to ensure that somebody who engages in mediation does not lose out on the right to litigate a case if mediation doesn't work out, and you can lose that right by delaying. So if you take over 2 years to take a personal injury case, then you're what's called statute barred. You've run out of time to take a case even if you still have a good case. So this section would allow you to put the egg timer, so to speak, on its side. for a while if mediation is being attempted during those 2 weeks. So the egg timer is automatically continued again then 30 days after either of these two events. There's a duty included on a mediator that the mediator must inform the parties of the relevant dates. It does raise a couple of uncomfortable questions for me. So what if there's an unsigned agreement at the end of it? You still have to write to, it adds a layer of administration if nothing else, and it's something that you're going to have to keep an eye on. I suppose, it's interesting to see how this is going to roll out in practice. It's likely to be straightforward for mediations that have been referred under Section 16 by the courts, but the Act, from what I can make out, applies to all mediations. So this doesn't say it's just referred to those Section 16 mediations. So, could be you, it is you. That's, if they have a right to litigate something. I'm just a little uncomfortable by that. Which mediations does this apply to? I think all. And if so, how is this all going to roll out in practice? How is it going to be policed in non-court referred mediations? If a mediator is unaware of this section or neglects to carry it out, and one of the parties becomes statute barred, it could get very messy. Procedure isn't clear to me as to how the court service is going to be able to monitor the variables that might surround this. I mean, it's quite clear how they do it in other scenarios where people's voluntariness is compromised and they have to go through some alternative to the court scheme, like the injuries board, where there's central administration of stopping the clock for a while, whereas this one, no. Section 19 then is provides similar administrative functions, allowing the court to adjourn litigation proceedings while they're ongoing if mediation that's relevant to those proceedings happens. Adjourn, perhaps one of my learned legal friends could check if is adjourn the right word to use there, or should it be putting a stay on proceedings? I presume they have the correct words there, the legislators. Never make a presumption like that. Anyway, fees and costs then under Section 20. So this says the parties shall either pay the costs as per an agreement to mediate, or they share the costs equally in mediation. What I would say is it says equally, and it doesn't say jointly and severally. So just be mindful of that perhaps when designing your payment structures. So you could read this as separate debts from two different people. In fact, you should read it as that. This notion of equal. So the full amount couldn't be recovered from whichever party has a mark, or whichever party is willing to pay. So this could lead a mediator in a bad debt situation fairly easily, particularly one person is being very obstructive and the other person says, well, I don't have anything to do with them anymore and that's not my debt, that's their debt. So perhaps a better approach is to include a joint and several liability clause in your agreement to mediate with parties, so then they've agreed it with you contractually in advance that if the other person doesn't pay or can't pay, that they will pay for the full mediation and the mediator isn't left carrying the can. And then you'll see here, the fees and costs of mediation shall be reasonable and proportionate. Now, you heard it first here. This is relevant to practice, however. It may make justifying our fees more important. Things like doing more time costing, actually showing how much time you've put into, if you're drawing up agreements afterwards, if you're spending time on phones, talking to people, that you record all of that time to demonstrate why your costs are reasonable and appropriate. Section 21 then I mentioned to you earlier on, related to Section 16. So when the court has invited people to go to mediation and they say no, what happens then? Well, this is, I suppose, the stick approach rather than the carrot approach. And from what I've read anyway, coming out of Europe, is other jurisdictions which have used more of a carrot approach. They've inverted this to say, if you do mediate, we're going to refund you the fees that you paid for the stamp duty of entering this case into the litigation process and things like that. Whereas the Irish approach follows the English approach, which is if you were unreasonable in your failure to enter into mediation, or you refused unreasonably, then we're going to penalise you as to costs. So the normal rule in Ireland is that costs follow the event. So if I litigate against you and I win, then you have to pay my costs. However, this says if I litigate against you and you suggest we mediate and I say no without good reason, then even if I win, I may still have to pay both of our costs, or at least I'm going to have to pay my costs. Um, Again, the best practice coming out of Europe says this isn't the best way of encouraging mediation. They tend to suggest if you're going to go about either carrot or stick, use carrot instead of stick. And the type of carrots that they use in different countries, as I was saying, um, giving you money off costs that you've already paid. The state reimburses them. And the most recent cases coming out of England where this gets litigated from time to time are, are less and less invoking this notion of penalising somebody for not entering into mediation. Then you have the amendment of the Civil Liability in Courts Act. That's really bringing that particular act. That was one of those acts which encouraged mediation in the past, is bringing it into line with Section 16 of this Act. Which then brings us to Section 23. And Section 23 is about these mediation information sessions. And these things are best practice from anything I've read out of the EU. And again, designing them right is going to be important. And that was what Minister Flanagan said at in the clip that I showed at the beginning. That we're yet to decide how to design this, and he's looking for input in how to design this. And I suppose my own personal input into this is if the scheme gets brought in, I'm anxious that it's mediators themselves who get contact with the people, because if you've a person selling you a service and that person is very clear on the service, then they're more likely to sell it well. How this is going to happen, you see, again, this is one of those may provisions, so it's not shall, so the minister may never do this. Hopefully he will, and in fairness to this particular minister, he has driven through this bill at an impressive velocity, where some of his predecessors were quite slow. That much was impressive, and he has undertaken and has asked us and the politicians around him to accept his bona fides, that he is pushing this through and engaged with it. In fairness, it is here, so I would hope that when delivering this, that the scheme will be well delivered, and that's one of the debates that we do need to have: is how should these things be designed? Who should be responsible? Would it be state-employed mediators? Would it be private mediators? Who would be paying for the mediation information sessions? And importantly, from my point of view, I would say that ideally it would be mediators that are providing the information sessions, and that there would be some human contact, be that physically or be that online. How that will actually operate may depend on the type of case. Here it's for family cases and succession cases. Seem to be the two particular areas that it's zoning in on. For family, there are existing practices within the family mediation service which provide mediation information sessions. You see there are some projects like the one in Dolphin House, where it was available right next to the district court setting. Those kinds of projects, again, there have been a lot of successful reports on those projects both in Ireland and elsewhere. Should they be rolled out generally? I think reviewing the experience of the Dolphin House project would be one good starting point there. Perhaps in relation to succession, is there going to be a succession mediator in every territory available, or every county or every town available for somebody to talk to? Maybe not. That's something where we could have technology bridge the gap in getting clients who could have use of mediation meeting with a mediator to talk through it with them. It'll be interesting to see where it goes, and it is something that we should all engage our minds in now, because it's the next phase of development of the regulation of mediation. That being Section 23, there's a lot under there about putting that they're supporting administrative sections, I would suppose, for everything under that. Part 6 then just amends other acts, really in an effort to bring them into line with the reporting duties on solicitors in this particular act. One thing which, again, we've reached the end of things here, and I suppose I'd like to have a nugget for those of you who do get engaged in critically analysing pieces of legislation, is I'm a little confused by them mentioning sections 10 and 11 in these changes that are made to the Guardianship of Infants Act and the Judicial Separation of Family Law Acts. They seem to be saying here that solicitors should give to the applicant the names and addresses of persons who provide a mediation service and inform the applicant of matters referred to in sections 10 and 11 of the Mediation Act 2017. But section 10 and 11 are the confidentiality and enforceability sections. I would have thought it was the information sections myself. You know, I look forward to being enlightened by somebody. The email again is Paul at successionireland.ie. That's it really. I hope you enjoyed the run through the Act. There is a schedule as well that all relates to the council. They're all things that are going to be fielded by Sabine Walsh. One last thing to say, I suppose, is don't panic. The Act hasn't commenced yet, so if you're not complying with everything within it, just because Michael D. Higgins has signed it doesn't mean it's a law where somebody's going to come knocking on your door in the morning saying that you're breaking the law. But now is the time to start to adjust your practice to fit in with the obligations that are placed on you by this Act, and hopefully we can have a fruitful discussion about how best to do that on the 14th of October. I look forward to seeing you then. Slán Tamil.